Welcome back to the Deep Dive. We're here to help you cut through the complexity of the MPEP and get straight to the practical knowledge you need.
Today we're tackling MPP Chapter 1400, which deals with correction of patents. Specifically, our focus is MPP Section 1440, how reissue applications actually get examined.
Right. This is all about fixing mistakes in an already issued patent when it turns out to be wholly or partly inoperative or invalid. That's the key phrase, isn't it?
It absolutely is. That phrase unlocks the whole reissue process. So today our mission is to understand the special rules for these applications, their priority status, and critically, the really complex prior art issues introduced by the America Invents Act, the AIA.
Okay, let's unpack this, starting with the basics. Someone files a reissue application to fix an error. How does the patent office handle it compared to a brand new application? Does it just go to the back of the line?
No, not at all.
Right.
Well, it's true that a reissue application is examined much like a regular non-provisional one, same standards for novelty, obviousness, all that. It actually gets special treatment.
Special treatment? How so?
It gets special priority status. Examiners are generally instructed to pick these up and act on them ahead of their other cases.
Interesting. Why the fast track? Is it just courtesy or is there something more pressing?
Oh, it's very strategic. The MPP explicitly states special priority is given if the reissue is tied up in litigation.
Ah, okay, so if the patent's validity is being challenged in court right now.
Exactly. The office wants to clarify the patent status, the correct status, as quickly as possible because it impacts the court case and the applicant. They have to tell the office about the litigation, preferably right when they file the reissue.
It makes total sense. If a judge is considering an injunction or something, the USPTO's view on the corrected patent is pretty relevant. So notifying the office is like saying, hey, we need this resolved so we can take the corrected patent back to court.
Precisely. It speeds things up. But this priority doesn't mean they can skip the formalities. They still need to comply with all the rules, specifically 37 CFR sections 1.171 through 1.178.
And there's something specific about the oath or declaration in there, right?
Yeah.
Section 1.175.
Yes, that's quite distinct. The reissue oath or declaration has some unique requirements.
What makes it so different?
Well, it has to get right to the heart of the matter. The applicant needs to state two key things. First, that they believe the original patent is flawed, maybe a defective specification or drawing, or, crucially, that they claimed either too much or too little.
Too much or too little. Can you give us a quick example? That sounds like something that could happen easily.
Sure. Claiming too little is maybe easier to grasp. You just didn't claim the full breadth of what you actually invented. Maybe you put an unnecessary limitation in a claim.
Right, leaving valuable ground uncovered.
Exactly. Claiming too much, on the other hand, means your claim covers things it shouldn't. Maybe it reads on the prior art or covers something dedicated to the public. It's often a more serious issue during examination.
Okay. And the second requirement for that oath, something about intent.
Yes, and this is fundamental. The applicant must state that all the errors being corrected happened without any deceptive intention.
No deceit allowed.
None. Reissue is for honest mistakes, plain and simple. Not for trying to game the system or fix a patent obtained through intentional misrepresentation. And that's why the examiner's job is broader here.
Right. They can't just look at the new claims submitted in the reissue.
No, they absolutely have to dig into the original patent's file history. They need the full context, what was argued before, what was the scope understood to be, what exactly is the nature of this error being corrected now. It ensures that non-deceptive intent requirement is met.
Okay, let's switch gears a bit. Restriction practice. Most practitioners know this. The office says, hey, you've got two or more distinct inventions here, pick one. How does that play out in a reissue where you might be trying to add scope?
Yes. This is where it can get, well, messy strategically. Standard restriction practice does apply. The tricky situation arises when the reissue application includes claims to both the original patented subject matter and also new, previously unclaimed subject matter.
So, say my original patent claimed a specific chemical process. Now, in the reissue, I'm trying to correct the process claims and add claims to the apparatus used in the process. If the examiner says process and apparatus are distinct inventions, what then?
Then restriction might be required. And if it is, the MPP has a specific rule. The original claims, the process claims in your example, are considered constructively elected.
Constructive election. Sounds like legal speak for we picked for you. What does that actually mean for the applicant?
It means, practically speaking, unless they decide to disclaim all the claims, they have to proceed with examining only the originally patented subject matter in that reissue application.
Wait, so the very act of trying to add the new apparatus claims could force them to essentially put those new claims on hold in that application?
In that specific application, yes. The goal is to keep the examination focused and clear. If they want to pursue the apparatus claims, they generally need to file a separate divisional application for them. They can't usually pursue both the correction of the old and the examination of the entirely new restricted stuff simultaneously in the same reissue.
Wow, okay, so practitioners really need to think ahead about whether adding new scope might trigger a restriction that delays or complicates getting that new scope allowed.
Definitely a strategic consideration. Now, speaking of complications, let's talk about the big one. The America Invents Act, or AIA. This really changed the landscape for prior art.
Right, the AIA brought in the first inventor-to-file system and new definitions of prior art. How does this intersect with reissues, especially older patents?
What's fascinating here is how profoundly the AIA impacts prior art analysis in reissues. It all hinges on the effective filing date of the claims. That date determines whether you're playing by the old pre-AIA rules or the new AIA rules.
And then magic date is March 16, 2013, right?
That's the line in the sand. March 16, 2013, and the rule is quite strict.
How strict? Tell us about this AIA cliff I've heard about.
It's a cliff because if even one single claim in your reissue application needs to rely on a disclosure, needs support from something filed on or after March 16, 2013,
Just one claim.
just one, then the entire reissue application, including all the older claims fully supported by pre-AIA filings, gets pulled over that cliff. The whole thing becomes subject to the AIA prior art rules.
That sounds incredibly harsh. So a tiny amendment adding one feature in, say, 2014 based on a continuation file then could subject claims originally filed and supported way back in 2010 to the completely different AIA prior art standard.
That's exactly right. It forces applicants to be incredibly careful. They need to be certain that every single claim in the reissue finds its full support in filings made before March 16, 2013 if they want to stay under the pre-AIA law.
And if all the claims are fully supported by pre-March 16, 2013 filings.
Then you're safe. The entire reissue is examined under the older pre-AIA Section 102 and 103.
Okay, here's where it gets really interesting. Let's make this concrete. Give us a scenario. Say an application is filed in April 2013 after the cutoff, but it properly claims priority to a provisional filed back in December 2012 before the cutoff. Now we need to reissue that patent.
Okay, scenario one, the priority claim split. This is a great example. There are two potential outcomes here.
Okay, what's result A?
Result A, if all the claims in the reissue application, every single one, are fully supported by that earlier December 2012 pre-AIA filing.
Even though the main application was filed post-AIA.
Yes. If the support is pre-AIA for all claims, then you stay under pre-AIA law for the prior art analysis. You're relying on the earlier date.
Okay, but what if the reissue adds a new claim or amends an old one so that it now relies on new information that was only disclosed in the April 2013 filing?
Ugh. That's result B. That's the cliff jump. If even one claim needs that April 2013 disclosure for support for its effective filing date, then boom, the whole application switches. The entire reissue gets examined under AIA rules. Think of it like touching the post-AIA side. It contaminates the whole application for prior art purposes.
Got it. 1 foot over the line, the whole thing goes over. Okay, scenario 2. This seems maybe less risky. What if I have a patent based on a pre-AIA application, and during reissue, all I want to do is add a claim for priority or benefit to an even earlier pre-AIA application that I forgot to include originally?
Right. So you're just correcting the priority chain, but staying entirely within the pre-AIA timeframe.
Exactly. Does that trigger the AIA?
No, generally it shouldn't. As long as the patent being reissued, the newly claimed benefit application, and all the claims themselves are fully supported by filings before March 16, 2013, you stay under pre-AIA law. You're just establishing an earlier pre-AIA effective date, not crossing the 2013 line.
Okay, so the lesson is, adding earlier pre-AIA dates is fine, but adding support from post-AIA dates is where the danger lies.
That's a good way to put it. It really emphasizes the importance of that March 16th, 2013 date.
This all seems to tie back to a fundamental idea about what a reissue actually is. The MPP mentions this continuation principle. What's that about?
Right. This is key legal underpinning. It comes from a very old Supreme Court case, Grant v. Raymond, back in 1834. The basic idea is that a reissue isn't treated as a brand new patent.
It's not starting from scratch.
No. It's seen as continuing the legal rights, the patent privilege of the original patent. It's basically substituting a corrected version for the flawed original. That's why reissue claims are evaluated as if they had the same effective filing date as the claims in the original patent they replace.
So it continues the original patent's life. It doesn't start a new one. What are the implications of that?
Well, a major one is that you can't use reissue to claim subject matter that wasn't adequately disclosed or supported in the original patent application as filed. The correction has to be based on the invention as originally presented.
So even if you're broadening claims, that broader scope has to have had basis in the original disclosure. You can't add truly new concepts invented later.
Precisely. It's about correcting errors related to the original invention and disclosure, not adding new inventions. It's a correction, a continuation, not a do-over with new material.
That really underscores the challenge, especially when you mix this continuation idea with the hard cutoff date of the AIA. You need continuity with the past, but you're facing this sharp legal breakpoint.
It makes reissue strategy, particularly for older patents, incredibly complex.
Okay, let's try and boil this down for everyone listening. The key takeaways from MPP 1440 on examining reissues seem to be three main things. First,
Reissues get priority, especially if there's litigation. So if you're in court, tell the USPTO immediately use that priority.
okay.
Be really careful with restriction. If you mix original claims and totally new subject matter, you might face that constructive election and have to pursue the new stuff separately. Plan for that.
And the third, and maybe the biggest one.
The AIA date, March 16th, 2013. If any claim needs support from on or after that date, your entire reissue flips to the AIA prior art rules. You absolutely must know the effective filing date support for every single claim.
So what does this all mean in the bigger picture? You said the reissue continues the original patent privilege.
Yeah.
What's the strategic thought there?
Well, think about it. Because it's a continuation, not a new grant, any correction you make, even years later, has to tie back and be supported by that original disclosure. It highlights the importance of getting the original application as complete and accurate as possible because your ability to fix errors later is constrained by that initial filing. And the AIA just adds another layer of potential hazard onto that historical dependency.
A powerful reminder about the long tail of patent drafting and prosecution. Definitely something to keep in mind.
Indeed.
Before we wrap up, we want to give a special thank you to Mike Shepard, the creative director behind this whole MPP audio series.
Yes, thank you, Mike.
And now, the important disclaimer. This summary of the MPEP was generated using AI tools. It's for general educational and informational purposes only.
It might have errors or omissions, and it is absolutely not legal advice or a substitute for proper instruction.
For authoritative guidance, please always consult the official MPEP itself, talk to a qualified instructor, or seek advice from a registered patent practitioner.
Thank you for joining us for this deep dive into examining reissue applications.
We hope you found it useful. Catch you on the next one.